Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. On June 18th, 2025, Judge Hippler will entertain the defense's May 20th, 2025 motion to continue the trial. There have been multiple reasons that the defense has cited, including the fact that Mr. Kohberger's due process privileges have been impacted by the recent airing of the NBC Dateline television special entitled Terrible Night on King Road. He cites too the seminal case of Shepard versus Maxwell. That's a U.S. Supreme Court case that says sometimes a continuance is necessary if there is a lot of negative pretrial publicity. The defense expressed their concerns that it was not just the information that was divulged during that Dateline television special, but also the manner in which it was presented that appeared to be completely negative to Mr. Kohberger. The defense has also pointed to an upcoming book from a very well-known and prominent true crime writer, James Patterson, about this case. The state of Idaho has not yet filed a response to that motion. We anticipate that once they do, the state's response will be met by a reply from the defense. When those two items hit the docket, we will, of course, notify you. There is some information that can be found from the very first jurist in this case, Judge Megan E. Marshall, that may suggest that a continuance is appropriate. Judge Marshall not only was the trier of the law, the first one in the case when it was back in Latah County before change of venue occurred in September of 2024, due to negative pretrial publicity. She signed the order finding probable cause. She signed the arrest warrant for Mr. Kohberger, both of which occurred on December 29th, 2022. 4 days after Mr. Kohberger's arrest on December 30th, 2022, the parties, that is the state of Idaho and the defense, submitted a stipulation to Judge Marshall asking for the very first non-dissemination order that was entered in this case. That stipulation was dated January 3rd, 2023, the same date that Judge Marshall entered the non-dissemination order, the first one. The state and the defense, in substantiating the reason why there should be a non-dissemination order in the case, addressed words to the effect of maintaining the integrity of the judicial process, albeit so that the case could be tried in a court of law and not in a court of public opinion or in the media, which is exactly what Judge Marshall referenced 10 days later when she called an off-the-record conference on January 13th, 2023. Minutes from that conference were sealed. Present at that conference were Judge Marshall, the state, the defense, and also attorneys for victims/witnesses. Judge Marshall stated, in referencing that first non-dissemination order that was just 10 days old at that time, in a case that was just a couple of weeks old at that time, she referenced the fact that she tried to ignore publicity surrounding the case. That it appeared to be, at least in my opinion, she was doing that as the trier of the law. and possibly, in a complete speculative opinion that I'm giving, because she herself as a jurist did not want this publicity somehow impacting any of her decisions. She also talked about the importance of having the case tried within the courtroom and not anywhere else, and the importance of this objective to due process, which is what the defense is raising in the motion to continue Mr. Kohberger's due process privileges, and that time and space might be necessary in order to guarantee them. So if a judge who signed the order finding probable cause, who signed the warrant for Mr. Kohberger's arrest, and who signed the first two non-dissemination orders in the case concerned possibly about negative publicity impacting her, was it possible to voir dire citizens who are not judges on how negative publicity might impact them, even on a subliminal level, an unconscious level that they're not aware of? Judge Hippler, in the order of May 15th, 2025, found, based on sensitive information not previously publicly circulated, that was reported during a recent Dateline TV program, seems to tell us that this was evidence from the case which may or may not be admissible. It somehow found its way to the media, and he addressed the fact that such violations not only undermine the rule of law, potentially by persons charged with upholding it, but also significantly impede the ability to seat an impartial jury. Ladies and gentlemen, impartiality is a requirement of due process. I'd like to hear your thoughts and your comments regarding this matter. If you like our content, please be sure to hit the like button. And if you have not already subscribed to our channel, I would greatly appreciate it if you would consider subscribing, because it will notify you when new content appears on this channel. And again, everything stated here is pure opinion, it's speculation, and it's made for discussion and educational purposes only. This is Kathy. Until next time, thank you so much for joining us today.